my lady, yes, of course. May I start by taking you to Huawei ZTE, if that might be of assistance? There's a discussion of this case, which isn't in the bundles, but there's a discussion of this in the Court of Appeal decision in Unwired Planet at JA2 tab 23. It's at paragraph 234, which is page 819 of the bundle. So it's 234, page 819. Yes. So 234 to 236 introduce the issue. And if I could ask you to have a look at those, there's a little reading to be done, I'm afraid, but if I could ask you to look at those three. And in particular, you'll notice from 235 and 236 that what is being considered here is a case based on abuse of dominant position. It's not a contractual case. So the court's question is addressed in 237. So the court then asked in substance, in what circumstances the bringing of an action for infringement by an undertaking in a dominant position and holding an SEP, which are given undertakings to the standardisation body to grant licences to third parties on FRAN terms, seeking injunction prohibiting infringement of SEP or seeking recall of products of the manufacturer of which SEP had been used, was to be regarded as constitutional abuse contrary to Article 102. The next two paragraphs, 238 and 239, first describe what you might call the normal case of an undertaking holding a patent. And then in 239, it goes on to discuss the specific case in which the patent is a standards essential patent, whereby different considerations arise. Yes. Now at 240 to 241, the court goes on to consider that, therefore, circumstances may arise in which an SEP owner may find their ability to seek that kind of relief barred. And then in 242 down to 245, this sets out the steps that the CJU stated the proprietor must comply with, and I'll come back to must in a moment, but must comply with in bringing the case against an infringer. So in 243, step one is these ones I butchered earlier, but step one is that the proprietor must alert the infringer to the infringement complained about. In 244, secondly, the proprietor must present to the alleged infringer a specific written offer for a license on FRAND terms. And at 245, it's for the alleged infringer to respond to that offer in good faith, etc. Now, 246 to 247 comprise two further obligations, which are on the alleged infringer which is in 246, it has to submit a counter offer, and in 247 to provide appropriate security. They don't really arise here. And then in 249, two other points should be mentioned at this stage. First, if no agreement to reach for the counter, the parties may request that the amount of royalty be determined by an independent third party without delay. Now, we've done this with our proposal to go to arbitration. And secondly, there's a point about challenging the validity of patents. And then at 249, you have the main, and 250, you have the main conclusions. Now, so 249 deals with what you might call coercive remedies, and 250 deals with damages. But of course, if there's a declaration as to what the reasonable license fee is, then the damages itself will be resolved as well by any declaration as to the FRAN terms. Now, to be clear, my Lord Justice Birss, at first instance, held that this was a safe harbour provision, not mandatory, and that was upheld by the Court of Appeal and the Supreme Court. But in my submission, that was in the sense of that you can get your offer wrong. So if you're a patentee, you can make an offer and it can be wrong, so long as it's not such as to derail the negotiations entirely, and so long as you offer FRAND in due course. And that in due course may be at the end of proceedings, the court declares FRAND and then you offer it. But if our declaration is granted, then we submit advance will have to offer it before bringing a case in the UK courts and offer it on the terms declared, because any other offer could not be considered in any sense a bona fide or good faith offer of a FRAND license, because it would be contradicted by something that was res judicata between the parties. So we submit that if UK patent proceedings were to be brought, the declaration we seek would be a defence proactively established by the declaration and which we would be able to rely upon. It would be a declaration, the substance of which was that we had no liability, or at least no liability, unless they offered us a license. And as we said, we would take it. And that is why I do submit it does have close parallels with the Arrow case, because in each case, the potential infringer is, in advance of any proceedings being brought, seeking a declaration as to fact or mixed fact and law, the substance of which would be so as to provide a defence in any future patent action. And if I can take you now to the Fujifilm case, which is one of the Arrow cases in the bundles, which is in J2 tab 18. The section I want to go to starts on the paragraph 100, which is 274. This is dealing with Gateway 9. I'm actually just going to show you a couple of paragraphs relating to the tort gateway, so I don't have to come back to this later, and also because it's part of the context that's relevant to this specific point. So page 274. So that's Gateway 9 tort, and in paragraph 102, the judge starts with consideration of Foley and Fisher, which is the well-known Court of Justice case, which establishes that negative declarations fall within Article 7.2. And if I can invite you just to read that paragraph, I don't think one needs to work through the quote. And then at 103, it says counsel for FKB submitted the Gateway 9 should be interpreted in the same way, and he points out that what was now Article 7.2 of the regulation was the historical antecedent in the modern tort head of jurisdiction, which is now under Gateway 9. And at the end, he says, furthermore, he argued for the reasons given by the CJU for holding that Article 7.2 should be interpreted extending negative declarations where persuasion should be followed. And then paragraphs 106 and 107. So in 106, he concludes that Gateway 9 is at least as wide as Article 7.2 and arguably wider still. And this is relevant when we come on to the Gateway 9 argument. I do not consider it necessary to consider all decisions in detail. The conclusion I draw is that the balance of authority favours interpreting Gateway 9 consistently with Article 7.2 where it's possible to do so. In any event, there's no authority binding me which holds that Gateway 9 should not be interpreted in the same way. With respect to negative declarations, in my judgment, it makes sense to do so, given the apparent policy behind the introduction of Gateway 9 and the desirability of a consistent approach. And it says, moreover, whilst it's true, domestic regime is more flexible than Brussels 1 regime, which doesn't allow for the application of foreign convenience, that consideration favours a broader interpretation of Gateway 9 rather than a narrow one, and he finds the reasoning of Foley and Fisher persuasive. And then in 107, which is of relevance to the point we're discussing now, turning to the second issue raised by Adbury, Counsel for Adbury submitted the error declaration claimed by FKB was not in terms of declaration that no tort would be committed by FKB. It was not in terms, a declaration that no tort would be committed. And then he refers to section 74. I do not accept this argument. As I've already said, it is important to focus on the substance of the error declaration sought by FKB rather than its form. In substance, it is a declaration that FKB will not commit any tort, so far as patents in Family 5 are concerned, because they will have a Gillette defence to any claim for infringement. And we submit much like the present case, where it's complained that Vestel's declaration is not in terms that a tort would not be considered, but nonetheless, we submit the effect of it is that would be that without being offered the Frown licence, no action could be brought. And if I could also deal with one last point in this, show my lords and my lady the Pfizer decision, Pfizer and Roche, which is in tab 25. At page 390. And if I could ask you firstly to read paragraph 61 down to 64, second indent. So you see in 64.1 and 2, we being Roche, were arguing that either the court had no strict jurisdiction to grant declarations where there were no legal rights, or in the alternative, that there was a hard-edged point of principle that means that the discretion couldn't be exercised to grant declaratory relief where there were going to be no rights. And this was a case on the facts where just after the issue of proceedings, Roche abandoned the UK designations of all relevant patents. So it was not in dispute between the parties at trial that there were no UK patents, relevant UK patents, nor would there ever be any relevant UK patents. And so that was relied upon by Roche to say that the declaratory relief was strictly barred. If I can then take you down to paragraph 78 on 394 and 79. And this cites the Mr. Justice Henry Carr's decision in Fujifilm, where by trial the patentee had abandoned the UK patent protection, was offering undertakings that would not obtain relevant patents. And then down at 82 in the bottom of the page, my lord said, standing back from the details of an arrow jurisdiction, of course there is no general threshold jurisdiction requirement that the defendant must actually have some kind of legal right in the first place before the court's wide declaratory jurisdiction can be exercised, etc. And then going down to 86, it says, taking stock, in my judgment, the position is that following Roche's first submission, 64.1 above, it is wrong. This is one about jurisdiction proper, because it purports to place a limit on the court's power to grant declaration, even where it would serve a useful purpose. That is not right, because the only relevant limitation is concerned with useful purpose. I would characterise Henry Carr J in Fujifilm as a case illustrating why the first point is wrong. The fact that analytically, by the time the question came to be decided, it was true that there was no longer dispute before the court about the existence and scope of Abbey's legal rights, did not mean the declaration would serve no useful purpose, and indeed the declaration was made in that case. And then the first sentence of 87 says, as for Roche's second submission on hard-edged point of discretion, the first part is wrong for the same reasons, for the same as the first submission. So we say the court can make declarations without there being an extant asserted right, or even in the case of both AbbVie and Pfizer, ever there being a likelihood or possibility of a UK right because of the abandonment of the patent applications. And it can do so where it serves a useful purpose, including one, the substance of which is to provide a defence to some or all of a potential future patent claim. Now, my Lord Justice Birss rightly says we've not pleaded that they've abused Article 102, but in the same way, in an arrow case, you can't plead that they've said you've infringed a patent because the patent hasn't been granted yet, and indeed may never grant. And here, they haven't brought a claim against us in the UK in a manner which would engage the requirements under Huawei and ZTE. So they haven't breached this yet, but this is a proactive declaration that if they did try to sue us in the UK, they would breach it. And we say that that is the same as an arrow declaration, which says that even in the future they sought to sue us in the UK, then we would have a defence under the Gillette defence. Now, I should say an arrow declaration is normally brought in circumstances where there are future applications which are hanging over the defendant's head but which haven't been granted yet. Because a tactic often used in the Patent Office is to keep alive a whole series of what are called divisionals, basically identical patent options, and you get one granted, assert it, and then you leave the rest back to come over the horizon when you see how the first comes on. And the arrow declaration is normally used to provide clarity and a defence in advance of the grant of those patents. my lords and my lady, I don't think I can take that any further, subject to questions you have now. So I don't mean now in a peremptory sense. I mean questions you may have. I have gone slightly out of my path. I think if I might, I was just considering things over lunch. If I could address you briefly on the tort gateway, because I've actually covered most of the cases I want to go to on that, and then finish off on serious issue and forum. Yeah. So the overall structure of my submissions on the tort gateway is that Gateway 9 and Article 72 are interlinked, and I can take them largely together. That's not only because they're conceptually interlinked, but because the court in Brownlee confirmed that Gateway 9 was designed to reflect and indeed be broader than Article 7.2, and the Gateway 9 case law is built upon the Article 7.2 cases. Now, I accept to fall under this head, the claim has to be one which itself relates to tort as properly construed, and that there is no provision under the Brussels regulation equivalent to Gateway 4 for closely connected facts. And that's the AMT Futures case to which my learned friend Mr. Pickford refers to. Secondly, we accept the test is the one in Calfellis, which I will show you shortly. And thirdly, we obviously rely upon the well-known Foley and Fisher decision for negative declaratory relief, and also Fujifilm, which we've been through. So the basic test for tort, if I can show you Calfellis, it's in Joint Authorities 3, tab 28. And the facts don't really matter. I can start, if I may, at paragraph 14, which is page 5584 of the decision. So 14 just poses the second question submitted by the Bundesgerichtshof. And the answers are given at 16 to 18 over the next page. And 17 and 18 are repetitive, but it states that tort delict and quasi-delict covers all actions which seek to establish liability of a defendant which are not related to a contract within the meaning of Article 5.1. Now that is actually quite a broad test. It does have some limits. Notably, it has the limit in respect of actions which fall within Article 5.1, now 7.1. And also, notably, where an action is brought against a party for recovery of property where the recipient themselves owed no duty to the claimant and committed no wrong. So those are really unjust enrichment type cases. My learned friend refers to 3 of them. But, so he refers to a Reichardt case, which was what's an action Paulien under French law. He refers to Kleinworth, Benson and Glasgow, which is unjust enrichment for sums paid under an ultra-virus interest rate swap, and an insurance case called Excel Insurance, which is liability between co-insurers in the event of what's essentially an overpayment by one of them. Now, each of those cases were held to fall outside of Article 7.2, as it is now, as there was no harmful event or threatened wrong. But subject to that specific class of non-wrong-based liability, the test under Article 7.2, as stated in Calfellis, is a broad one, and plainly that covers the tort of patent infringement. The next question is the application of Calfellis in a negative declaration scenario, and that's been addressed by Foley and Fisher. Given the time, I won't take you to that, but the thing to note about Foley and Fisher is that the court was very aware when giving that judgment of the fact that allowing negative declaratory relief to be brought within Article, what was then 5.3, now 7.2, involves a reversal of the normal roles, and therefore gives the normal defendant, they're the claimant, the right to choose a forum for themselves within the limits of the convention. And that's also true of the Tatry decision, which is referred to in paragraph 49 of Foley and Fisher. Now, our case is about whether and to what extent the patentees would be entitled to relief for the infringement of their UK patent rights. And in my submission, there's no dispute that a UK patent right is a tort within Article 7.2. Nor can there be any debate about the geographical requirements of such a case, because both the Act and the accrued liability arise in this jurisdiction because they're UK SEPs. And my clients seek a declaration, which in my submission is a form of negative declaratory relief about the scope or extent of liability under the UK SEPs in their portfolio. Now, I've already addressed you on the Fujifilm case, and the fact that the Fujifilm case says that one has to have regard to the substance rather than the form of the declaration, and I've addressed you on what we say the substance of our declaration is.
Do we need to concern ourselves with the terms of Section 74?
I don't believe so. The terms of Section 74 are just an explanation of why a narrow declaration is brought in the form it is, which is a declaration of fact about the defendant's product, rather than just seeking a declaration in respect of the ungranted patent.
What is it about Section 74 which forces that?
It might, let me just see, it's possible it gets caught in. So I'm just thinking if it's in the authorities fund law. Can you put it up?
Well, don't worry about it now.
I was just trying to make sure I got the wording correct, my lord. Sorry, it's not bad. I can find out now if that would assist, or we can deal with it very briefly and reply. I don't think it affects the substance of any of the submissions.
Okay, well, let's come back to it if necessary.
Can you bring it up? Can you bring it up? My lord, I'll get a copy to hand and I'll address you very shortly then. But to summarise, under the tort head, I would invite the court to take the following 6 propositions. Firstly, that Article 7.2 is broadly defined, covering all actions seeking to establish liability which are not related to contract, and that's the Calfellis case. Secondly, that it's equally engaged in the context of negative declaratory relief, and that's Foley and Fisher. Thirdly, Gateway 9 is similarly broad and similarly engages negative declaratory relief, and that's Fujifilm, which we have seen. Fourthly, when considering declaratory relief and negative declaratory relief, it is the substance of the relief which matters, not the form. And in the patent context, it's no bar to declaratory relief that the declaration is not in the strict form of a declaration that no tort be committed. It is enough that the substance of the declaration establishes a defence to infringement, and that's Fujifilm. Then turning to the facts of the present case, and fifthly, we would submit that the declaration sought in our present case satisfies that test on our primary case, namely that unless a license is offered, the declaration of the FRAN terms will bar the bringing of a claim against Vestel. But in any event, and sixthly, we would submit that it's enough that on our fallback case, the substance of the declaration establishes a defence which delimits or restricts the remedies to the infringement claim, in particular remedies of injunctive relief, delivery up, etc. And in our submission, in the premises, the declaration sought in this action we respectfully submit do satisfy the requirements of both Article 7.2 and Gateway 9.
Shackfield, I promise not to ask you very many questions, but is your case that your client is committing a tort today when it sells the televisions or not?
It must be. We accept that there will be valid and essential patents.
So whatever it is you're not wanting a declaration that you're not committing at all, because you accept you are committing at all.
Well, no. In a sense, yes. In a sense, that's right. But we are wanting a declaration that will establish a defence to that.
We won't establish a defence to liability, will it?
Well, it'll put my learned friend on the horns of dilemma. Either he will offer us a license, in which case there will be no liability because we'll be licensed, or he won't, in which case his claim in my primary submission will be barred. Alternatively, the scope of the relief he's able to obtain will be delimited, in that he could only obtain a reasonable royalty by way of damages, and that itself will be at the FRAND licence rate. And that's, if you recall, at the end of the Huawei and ZTE section I showed you from Unwired Planet, the conclusions in Huawei and ZTE were that a patent owner could not bring a claim seeking coercive relief, but they could bring a claim seeking damages. But of course, at least under UK law, the damages would be the reasonable royalty. So in effect, any claim against us would be limited to the FRAND terms declared by the court.
Yes, but in terms of formal analysis, if you have your declaration, it does not give you a defence to liability for infringement. It gives you a reason why the court should not exercise its discretion to grant an injunction. Is that right?
Well, I would put it in two ways, actually, my lord. So my submission would be that in terms where a FRAND licence has been declared by the court, it would be abusive, both as a matter of abusive process type abuse and also under Article 102 to bring a claim without offering us a licence at all. But my fallback is certainly the one that my lord has just mentioned, yes. That the sort of minimum will delimit the exposure we have, and I submit there's nothing wrong in that. What logically, I would rhetorically ask, is the difference between a claim that can be brought, a claim that can't be brought at all, and a claim that can be brought where either no liability accrues or where the declaration determines the most important part of the liability. In my submission, obviously the outcome is different, I accept that. But in my submission, there's no jurisprudential distinction between the two. They're all declarations, the purpose of which is to remove or delimit liability in this jurisdiction.
Well, I think one might get caught up in a semantic debate as to what you mean by liability. But I understand your position. You might be able to get rid of the action entirely as an abuse, but even if not, even if you were liable for damages, you could defeat the claim from an injunction, and you say that's enough.
Indeed, and the damages claim itself would be limited to the FRAND royalty rate, because that would have ex hypothesized been determined to be the reasonable royalty between the parties.
It doesn't stop you being liable.
No, sorry, that is true, because you're absolutely right. And one of the benefits of the declaration I mentioned right at the outset is that an additional benefit of declaration, it means that we actually understand what our exposure is within the jurisdiction. So you're absolutely right, my lord, but nonetheless, I rely upon the ability for us to understand what to dispel the commercial uncertainty in the jurisdiction is part of the benefit of this declaratory relief we're seeking. Gateways 3 and 4 are very, very short points. If for some reason there was jurisdiction against Phillips, but not against Advance under Gateways 9 and 11, then we would submit that Advance should in any event be joined under Gateway 3. Advance is, after all, the entity which the patent owners, including Phillips, have charged with negotiating and granting licenses on behalf of its members. And Gateway 4A is, I don't detect any argument that means a Gateway 4A will arise. I was formally reserved my position pending see how my learned friends develop their cases. if I can return to no serious issue to be tried, I've outlined in my little period of jumping around just before the short adjournment, I've outlined the 7 points, I think it was, that we rely upon in relation to serious issue. And I've outlined what my learned friend says in response, which were the 5 issues that I identified to my lords and my lady. I think I had got to his 3rd point, which is his TQ delta point. So if I can take my lord and my lady to the report in relation with respect to the TQ delta case, and I'll outline the facts to it. It's in J3 Cat 26. This was a case which had had an extreme fact pattern. The defendant there, Vestel, had been held to infringe a UK SEP, but one which only had 3 months left to run. Although they had previously said that they would take a RAND, as it was rather than FRAND, a RAND license, after trial they changed their position, refused the license, and adopted to be injuncted from the UK market instead, paying all of the damages asked for by TQ Delta. Vestel gave formal undertakings not to seek a RAND license in respect of the UK in the future. TQ Delta nonetheless sought to press ahead with a declaration of RAND terms, but this was refused by the Court of Appeal. And TQ Delta also sought to add, at a later stage, a declaration that the defendant was an unwilling licensee. Now, unwilling licensee is a term which is sometimes used in the telecoms art to describe an implementer who has become disentitled from taking advantage of the RAND undertaking because of their own, what you might call, bad behaviour. It was said by TQ Delta that the relief sought would have a useful purpose by reason of the binding force as res judicata of that unwilling licensee declaration in other jurisdictions. The Court of Appeal disagreed, holding on the fact that there would be no useful purpose in the declaratory relief, and they said there'd be no useful purpose in this jurisdiction since Vestel has said they did not want and undertook not to seek a FRAND license here. And the court also said there was no evidence that the declaratory relief that Vestel was an unwilling licensee would have any role as res judicata in any other jurisdiction, or even evidence in that litigation in any other jurisdiction was likely. So this was really a decision on the facts. Importantly, the court did not in any way, in my submission, undermine the role of declaratory jurisdiction where an implementer does want a license. And if I can take to paragraph 37 of the discussion. That's on page 264. And you'll see, if I can read it, the court enjoys a broad, flexible jurisdiction to grant declaratory relief. This court made clear in Messia, Doughty, etc., the jurisdiction is confined to by the exercise of the court's discretion rather than by its jurisdictional thresholds. And then he goes on to, the court goes on to discuss FSA and Rourke. And then at 38, it says, before the change of tack, which was initiated at the hearing before Henry Carjay by Vestel's indication that they no longer wish to take a RAND licence, and completed by the irrevocable waiver tendered in Mr. Hargard's witness statement, the court's declaratory jurisdiction was entirely properly invoked as part of resolving Vestel's answer to the grant of the usual relief for patent infringement. Now, so the court will see that in 37, the court affirmed the broad, flexible jurisdiction to grant declaratory relief, and that in the first few lines of 38, the court reaffirms that the declaratory jurisdiction was entirely properly invoked in the period in which the implementer, that was there, Vestel, here my client, was willing to take a licence. So far from this case imposing some kind of jurisdictional bar for seeking a declaratory relief, it says quite the contrary in the normal scenario where the implementer is willing to take a licence. And you may also recall I showed you the passage from the Court of Appeal in Unwired Planet, which said in the context of that case, where the implementer had said they would take a license, that there was no jurisdictional expansionism in determining global FRAND licenses. So in my submission, there's nothing in the TQ Delta point, which is a case which turns on its own quite unusual facts. Turning then to Advance's fourth point, and Advance admits that REIT would serve no useful purpose because it's said that Advance has no authority to grant a license other than in its standard PPL terms. For your note, the judge made a finding of this in paragraph 9 of the judgment. So we submit that this is wrong or irrelevant for at least 5 reasons. Firstly, at a macro level, we submit it is a completely unrealistic suggestion to think that Advance would not be instructed by its members to offer a license in court-determined FRAND terms. To fail to do so, as I mentioned in my introduction, would be to render the pool an agreement between a number of likely dominant undertakings to set rates at a rate which had been determined to be supra-FRAND. The Article 101 and 102 problems would, in my submission, be horrific, and it's not realistic to suppose this would ever be done. And what's more, this is a summary judgment test. So my learned friend's case succeed, it has to be considered unarguable that the pool members would not act in that manner. There's also been some reasonably prolonged correspondence on this point, some of which in the confidential bundles, but I won't take you to it if I may. But in this correspondence, we've repeatedly requested an undertaking from Advance on its own behalf and on behalf of its members to make available to Vestel a licence on such terms as are determined by the English courts to be FRAND, and if not, to explain why. Now, on each occasion, Pal Gilbert for Advance have refused to answer. We've just stonewalled. But in my submission, the reason why they cannot answer is clear. And it's because they know the answer must be yes, the reasons I've just explained. But they know they can't confess to that while this matter remains before my lord and my lady. And if they really had confidence in their position on this point, they would have said so. But their failure to do so, in my submission, speaks volumes. Secondly, there's a closely related point, which is that for essentially the same reasons, a term to the effect which Advance rely upon, namely that they can only offer their PPL without the consent of the members, would itself likely be void under Article 101, and so in fact not a bar. Third, in any event, if the court, for the reasons we've discussed at length, in my submission, if the court declares the FRAND terms, and then an action against my client in this jurisdiction would be barred or seriously curtailed. And it matters not for this argument whether or not Advance can or cannot offer those FRAND terms. If they do not do so, that benefit arises. The fourth benefit is that the declaration it's the one that arises out of the terms of the pool licence, which I explained to my lords and my lady earlier. So the pool licence, in this sense, which Mr. Segan relies upon, is in fact against him. And fifthly, and in any event,
I'm very sorry, Mr. Jacksfield, I just simply didn't understand that submission. I'm sure it's just me, but that didn't make any sense to me at all.
My lord, sorry, I apologise. I took my lords and my lady earlier to the confidential clause 4.1 of the advanced pool licence. And the submission I made out of that, this was, if you recall, the contract to which we are not parties, but which we say poses a practical impediment against Advance proposing litigation against my client or individual pool licensees bringing litigation against my client in terms where the declaration has been granted, because to do so would render them in breach of that contract. And we say that's a practical benefit, even if not one that provides a legal defence to my client because of questions of privity.
Right, I think you referred to a pool license a few times. I think what you meant was pool contract or something. You didn't mean pool license.
Yes, sorry, you're absolutely right, and I apologise. Yeah, you're right, my lord. Yes, it's the pool contract.
Right.
The problem is because the pool is licensed under the patents within that confines, and often the pool is called the licensee, and the patentees are called the licensor, and the patentees are called licensees. But my lord is right. And the fifth benefit is that in any event, by declaring the FRAN terms, the commercial uncertainty as to my client's financial exposure in this jurisdiction will be dispelled. My clients will know what their exposure is. And for each of those 5 reasons, we submit that Advance's fourth point on no real prospects of success should be rejected. The last point, Advance's fifth point, is the one, if I can just remind you, because I've jumped around on this, this is the one in paragraph 45 of their skeleton argument. And it's the first sentence where it's stated, first, the courts only grant declarations which are concerned with the existence or scope of legal rights, public or private, citing FIS 7475. And I've been through FIS with my lord and my lady a few minutes ago. And as I've shown my lord and my lady, FISA is an authority for the exact opposite, which is you don't need an extant or even future legal right, public or private. So there is respectfully nothing, I submit, in Mr. Segan's points on real prospects of success, and certainly nothing which reaches anything nearly like the summary judgment standard, which is applicable to this part of the case. If I may, I was now going to turn to the last issue, which is forum.
Yes.
So the judge made no finding on forum, not needing to do so because of his other decisions. The right approach is that summarised by the Supreme Court in Unwired Planet. If I show us JA3 tab 27. And it's on page 2455. And if I could just invite my lords and my lady to read the first half of paragraph 94, just a bit on the bottom of that page, 2455. So that's our submission on what the test is. There's a more involved point about the test of the question of when the test is applied. My learned friend on this front refers to the Mohammed and Bank of Kuwait case, which is in JA1 tab 6. And if I could show my lords and my lady, page 1491. And Mohammed was a case of was a service in case, but it cites Lord Hoffman in a service out case. So one has to slightly unpick the ins and outs. The relevant bit is the quotation from Lord Hoffman at the bottom of page 1491. And so it's in particular about 6 lines from the bottom of the page, at H, Lord Hoffman says, of course, the court can receive evidence which was not before the master, and subsequent events may throw light upon what should have been relevant considerations at the time, that's the time the application for leave to serve out was made. But I do not think that leave which was rightly made should be discharged simply because circumstances have changed. That would mean that different answers could be given depending on how long it took before the application came on to be heard. And over leave, at the bottom of page 492, in the bottom paragraph, Lord Justice Evans, at point 4, agrees with this. He says, this is 3 lines at the bottom page, when the defendant alleges the court has no jurisdiction over defendant or over him in relation to any specific issue, that is A to G, then the relevant date is a date when the event in question took place, the issue of the writ, the granting of leave, or as it may be. I would therefore respectfully agree with what Lord Hoffman said, sorry, Mr. Justice Hoffman said about the Order 11 case, and then he goes on to make a specific observation that doesn't have relevance here. Now, the relevance of this relates to the German litigation brought by Phillips and other pool members in July 2020. So that was long after the application for service out, indeed long after hearing before His Honour Judge Hacon, several months after permission was to appeal on all grounds was granted by Lord Justice Floyd. On this appeal, advance rely heavily on the existence of the German litigation on the subject of forum because Germany has become its alternative forum. At first instance, it didn't have one. But in my submission, the position is more nuanced than that and involves 4 propositions. First, advance cannot rely upon the existence of the German litigation at the relevant point in time, the application date, since there was none at that date. Second, advance can rely upon the now existence of the German litigation to show that at the relevant time, Germany was a forum in which litigation could be brought. That's a legitimate basis to rely upon that evidence. But of course, the same is true in respect of any other jurisdiction in which has patent rights. There's nothing special about Germany in these regards. And as a consequence, at the relevant point in time, the application date, Germany was no more or no less prominent as an alternative venue than any other jurisdiction in which the pool has patent rights. And in my submission, it's not possible for Germany to gain prominence merely by reason of the fact that at a later time, a decision was taken to choose Germany amongst all the potential venues as the venue in which they decided to initiate their claims. Now, that's not to say in many service out cases, the existence of foreign litigation brought later is relevant, but that's because it serves to demonstrate certain objective facts which existed at the time the application was made. So you might have a contract claim where a later claim is brought in Mexico, and it demonstrates that many of the witnesses are Mexican, or it highlights that many of the witnesses are Mexican or Mexican law applies. But that's not the case here. The only relevance of Germany over any of the other alternatives which existed at the date of the application is that, well after the date, they selected Germany, and that's impermissible. So,
sorry, Mr. Saxfield, you referred us to Mohammed and Bank of Kuwait, and you showed us the passage on page 1491 at the bottom, which then refers to forum non-convenience, and then a bit you jumped over was that it indicated the top of 1492 A and B that in the context of forum non-convenience, is dealing with a moving target. first the master, then the judge at the first instance, or the judge of the High Court, and then by the Court of Appeal. This passage seems to be dead against you.
Sorry, I've taken it too quickly because of the time, my lord. May I, let me go back and explain this a bit more slowly, but the reason is because in his quote, at the time, Mr. Justice Hoffman was considering a service out case, but his last two sentences in the quote say the position is quite different when the applications for stay on the grounds of foreign convenience, that is in accordance with the court's inherent jurisdiction. In such a case, the appropriate time to consider the matter is the date of the hearing. And Mohammed was a service in case where, so it wasn't within the path of Mr. Justice Hoffman's decision, which I took my lord to, but falls within the obiter comment at the end. And that's why in the next paragraph, it talks about Miss Cast Frisk accepting that this means, as my lord cited, but that's a reference to the last two sentences of the paragraph. So Mr. Justice Hoffman was mostly considering a service out case where he says the relevant test, the bit I highlighted to you, my lords, and my lady, the relevant test is what was the position at the date of the application to serve out. But he made an obiter comment, and it's the obiter comment that's then relied upon by the court in Mohammed, because that was a service in case. And that's why this paragraph at the top of 1492 is based on the last two sentences of Mr. Justice Hoffman's quote, not the part I relied on.
All right, just so as you know, what's in my mind is that passage relates to the question of forum non-convenience, which is what we're talking about. And it's a different question, forum non-convenience, from a question of whether the court has no jurisdiction over a defendant. Forum non-convenience arises. The court does have jurisdiction over the defendant, but chooses not to exercise it on forum non-convenience grounds. I've got to tell you at the moment, Mr. Chairman, I'm not persuaded that the distinction you're trying to draw to say that the point about the movement doesn't apply to you is a good one. But
okay, my lord. I may have to spend a little time unpicking this. I'm just very aware. Sorry, I have taken this rather quickly, but I'm just very aware of the time. If I can start on 1491 at between D and E. So between D and E, it summarises Miss Cast Frisk's statement, case. And F says she relies upon the judgment of Hoffman J. That was a different kind of case, being concerned with the application to set aside leave given to serve notice of risk overseas under Order 11. And that's the passage I've just taken you to. There's the bits I rely upon relate to Order 12, Rule 81C, you see between G and H, which are to discharge the master's order giving leave to serve out. So so that part is about service out, and that's where the judge, then Mr. Justice Hoffman proposes the test I've taken my lords and my lady to. And he says, but then Mr. Justice Hoffman says the position is quite different when the application is stay on grounds of forum conveniens. Now, and then in such case, the appropriate time to consider the matter is the date of the hearing, and then we've got the bit from Miss Cast Frisk that my lord is referring to. Now, if one then goes down to 1492 at F, the judge says, Lord Justice Evans says, I would hold the defendant's application was properly made under both RSC Order 1281H and simultaneously under the inherent jurisdiction of the court. I will not express any view, however, on the question which has not been argued, although referred to in past as to whether Order 12 is a proper vehicle for an application made for form non-convenience, an application which can be made at any time under the inherent jurisdiction of the court. So, as explained in Kuwait oil tanker. Then it goes on to say this, just under G, this is an application for a stay of proceedings which themselves are rightly constituted and which, in the absence of a stay, should proceed to trial in the normal way. It is different from an application for an order which would set aside the writ or the service for all time subject to appeal. So that is saying this is not a case of the type that is currently before my lords and my lady. And the reason is because this was a service in case. The Bank of Kuwait was served, I think, in its office in London from memory of the facts. And then Lord Justice Evans says, in a case such as the present, the court in its discretion can lift the stay if suitable grounds are shown. And RSD Order 1284 requires an affidavit. The question for the court is whether the evidence in support of the application justifies the order which is applied to be made. The evidence may be produced then or subsequently, but it must be directed to the situation at the date when the application is made. When the defendant alleges the court has no jurisdiction, so this is the Lord Hoffman, the bulk of Lord Hoffman, when the defendant alleges the court has no jurisdiction over the defendant or over him in relation to any of the specific issues, that is A to G, then you'll note that it was A to 1H that's referred to it next to F for the purpose of Muhammad itself, not A to G. Then the relevant date is when the event in question took place, the issue of the writ, the glancing of lever, as it may be, and therefore he agrees with Lord Hoffman. And then in point 5 at B on 1493, the judge says, where a stay is applied for, i.e. for the future, I would hold the court there should also have regard to the situation at the date of the hearing, if only to avoid the absurdity of ordering a stay that is patently unjust through a change in circumstances. So, in my submission, the court here is clearly considering a scenario of the type he describes in his point 5, where he says a different test applies. The court here, and Mr. Justice Hoffman in the section of his that's quoted, distinguished between a service out case and a case where the action is properly constituted, but a stay application is made. And they say in the first case, one has to look at the evidence at the time of the application. And in the second case, the court can have regard to later events. Yes. So I'm sorry for that confusion. My lord, I am technically out of time. I would beg 5 more minutes indulgence. And I will just, if I may, and then I'll rush through the last few points, which are principally points of fact, and I hope to take, well, I will take very swiftly.
Yes, I'll carry on then.
So on forum, we rely upon 8 factors. Firstly, the subject matter of the litigation is the UK SEPs in the portfolio. Secondly, the objective of the case is to resolve the terms of a FRAND licence to those UK SEPs, and thereby at a minimum resolving the issue of infringement of those rights in the UK or obtaining a benefit in respect of an action brought. The third is the UK as Vestel Group's largest market for the relevant televisions in the world. And the fourth is that the second claimant, as regards the second claimant, the UK is its primary market, as you've already heard. Fifth, the UK courts have shown themselves to take a pragmatic and proactive approach to declaring FRAND terms, including, where the facts support it, worldwide FRAND terms. And that is something which no other court has yet done anywhere else in the world, at least to my knowledge. Sixth, and there is some evidence on this, the parties' negotiations, both oral and written, have taken place in English, as have all the technical discussions. Seventh, the draft license agreements proposed by Advance and by my client are all in English language. My client's draft license designates the UK law as the governing law, whereas I should be clear, Advance proposes the law of New York. And I apologise, there are 7 bases. And we submit that all those factors, individually and cumulatively, provide a strong basis. Now, Mr. Segan makes a number of points in reply. He says the right focus is Germany because there's now a claim initiated before the court. But my submission, the German, he says that. Secondly, there's a rehash of his TQ Delta argument, which I won't go over again. Third, he says that there's no evidence that a foreign court would pay heed to the view of the English courts. But in my submission, that's a strange argument, since the focus of his case is all about the impropriety of global friend influencing foreign decisions. And if he's right that nobody would pay any attention to it, then it just underlines that the UK court is the right jurisdiction into which to bring this case. His fourth point, he says that in the global pool, many of the SEPs are non-UK. In my submission, that misses the point, because all of the UK SEPs are obviously UK rights. And fifthly, he complains about forum shopping. Now, I only propose to address the first and fifth of those. The first is about Germany, and I've expressed my submissions on the law there. But what he's really saying, and this is revealed, if I can just show you paragraph 49 of his skeleton. In paragraph 49, he cites, towards the end of it, two passages from the Supreme Court in Unwired Planet. And what he's really saying is that the patentee should be able to choose, and that the patentee's choice should always trump the choice of the implementer. Now, in my submission, that's unprincipled, and there's no reason, and none is advanced, why a positive infringement case should jurisdictionally trump a negative declaration case. And furthermore, I would submit that's a viewpoint which is inconsistent with the Court of Justice's analysis in Foley and Fisher, which, as I mentioned earlier, very much acknowledged that the effect of the reversal of the normal roles, which a negative declaration entails, and that was a case which was adopted as relevant to Gateway 9 in Fujifilm. And the fifth point is forum shopping. In my submission, this is more against him than for him. And the reason I say that is there are, in my submission, good objective reasons to bring this action in the courts of England and Wales, not least that it's Vestel Group's preeminent market worldwide. If that's not the right place to resolve this case, you might ask, well, I would ask rhetorically where it is. Furthermore, I submit Germany has nothing to recommend it. There's no objective benefits to it other than the later initiated case. And there are further specific downsides to that. Firstly, no one is suggesting that the governing law of these contracts should be German law. I should mention that Phillips's draft proposes Dutch law. And secondly, unlike the UK, no German court has ever taken a determination of a FRAND license. What the German courts do is they adopt the Huawei ZTE approach, which I showed my lords and my lady. And the most common approach is the court asks first if the patentee has made a FRAND offer, and they will look at the offer made by the patentee. And if the answer is no, then relief is barred. And if the answer is yes, then you go to the next stage in the ZTE questions. And then they look at the implementer, etc. Sometimes the German courts will swap that round, and they start by asking, first of all, whether the implementer has behaved in a FRAND manner and made a FRAND offer. And if they have, then the courts go back and look at whether the patentee's offer was FRAND to start with. And again, if no FRAND offer has been made, then relief is barred. But the important point is that the German court, if the German court does not accept that one part or the other's approach is FRAND, then it will not go on to determine independently what the FRAND returns are. So it's a very binary system, which either franks one of the parties' offers or not. But no German court, to my knowledge, and certainly no case has been put forward, has ever involved an independent determination of FRAND terms, anything like the one in Unwired Planet. So the consequence, therefore, is that with litigation in Germany, it's entirely foreseeable that the parties will never learn what the FRAND terms are. So if my client's case is right, that advanced terms are not FRAND, then it's highly likely the court will not, that it's highly likely that the FRAND terms will never be determined in Germany. But that's no good for my client. My client wants to know what the terms are and wants to take a license. So for those reasons, we submit that the courts of the world are the appropriate forum for hearing of this case. And unless you have any further questions on that, I was going to just read to the court section 74, because in case that was of assistance, which just says, subject to the following provisions of this section, the validity of the patent may be put in issue in, and then A to E define certain defined proceedings. The argument in Arrow is that the substance of an Arrow declaration seeks to put the validity of an as yet ungranted patent in issue, and that was unallowable under either section 74 or the Barraclough principle. That was rejected at first instance in the original Arrow decision by then Mr. Justice Kitchen, and it went to the Court of Appeal in the Fuji and Abri case, where that argument was rejected by the Court of Appeal.
It has no bearing on this case, because you're not seeking to put in issue the validity of the patent in any event.
No, it has tangential issue, which is it just underlines why the Arrow declaration is just a declaration of fact about a particular defendant's product. But it doesn't, but my lord is right. So it's contextual. Now, I'm 10 minutes over. I apologise for that, and I'm very grateful for your indulgence. Unless you have any further questions, I think it's somebody else's turn.
Lady Justice Laing, Lord Justice Birss. No, well, thank you very much. And I think we'll take a 10-minute break. I'll make it 12 minutes past 3. We'll resume at 22 minutes past 3. Yes, Mr. Segan, I think.
My lord.
In fact, it's going to be Mr. Pickford.
Mr. Pickford, I'm
It
sorry.
is indeed.
Yes. Mr. Pickford.
Thank you, my lord, and my lady. There are three reasons why the appeal against Phillips, which is now based on one ground only, namely ground 3 of the grounds of appeal, should be dismissed. The first is that it would be procedurally inappropriate for the court to entertain Vestel's ground 3 on the basis of the claim, which now appears to underpin it. Ground 3 is not ultimately a point of appeal at all. It is, as I shall explain, an entirely new basis for asserting jurisdiction based on an entirely new underlying claim, which was never considered by the judge below at all. Now, I was going to say that the new claim was unveiled by proposed amendments last month, for which Vestel does not yet have permission insofar as they add matter. In fact, it now seems to be the case that Vestel are advancing their new basis for asserting jurisdiction on a new case that's entirely unpleaded and unheralded before late this morning. And that new case is that abuse of dominance, far from being out of the picture, as we were told just a few weeks ago, now seems to be back front and centre of the basis for explaining why this court has jurisdiction. Now, below, Vestel proceeded on the basis that its claim against Phillips was, and only was, for the tort of abuse of dominance, and that was advanced on the basis of principally excessive pricing. Now, Vestel made clear that it was not seeking a freestanding declaration as against Phillips. And then a month ago, Vestel abandoned both the claim for abuse of dominance and the concession that it had made that without such a claim, the court has no international jurisdiction to grant relief. And yet now, what we have in its place is this new unpleaded explanation for an assertion of jurisdiction based yet again on abuse of dominance. It's not appropriate to allow Vestel to perform this somewhat extraordinary series of multiple volte-face before this court. One reason amongst many is it's not actually acceptable to decide a case on the basis of something which isn't pleaded, which isn't evidenced, and wasn't heralded in any form before this morning in terms of the arguments about abuse of dominance. For what it's worth, I've had less than an hour during the short adjournment to consider that new case, and it is, I will submit, one that has a number of very serious problems. But it's obviously prejudicial to my clients to expect me to address all the defects of a case that we simply didn't know about until this morning. My lords, the second point, without prejudice to the procedural difficulties that Vestel finds itself in, is that ground 3 is unsustainable in any event. Notwithstanding the new abuse of dominance explanation for jurisdiction, Vestel neither alleges that tort nor seeks any relief in respect of that tort. Nor can the claim be regarded for jurisdictional purposes under Article 7.2 of the Brussels Regulation as being one for UK patent infringement. Vestel neither alleges that tort nor seeks any relief in respect of that tort either. Rather, the claim as pleaded is a freestanding one for declarations which depend neither on liability nor on non-liability in tort. And there is simply no jurisdiction to entertain such a claim under Article 7.2 of the Brussels Recast Regulation. So, without the allegations of abuse, Vestel's claim is simply not a matter relating to tort for the purposes of that article. And that's a complete answer to ground 3. A second complete answer to ground 3 is that Vestel cannot point either to jurisdictionally relevant damage so as to found a harmful event in the UK. Now, My third point is that Vestel's claim is not advanced on a coherent and justiciable basis. There is no coherent legal right or legal standard or other legal context that is identified in the particulars of claim by reference to which the declarations that it seeks could properly be determined. The best we have is the unarticulated case on abuse of dominance that it may potentially seek to move in the future. Well, that is wholly insufficient and an unacceptable basis for a claim for which Vestel seeks permission today. Vestel should accordingly refuse permission it needs to introduce the claim. So, my lords, those are the 3 points that I wish to make in my submissions this afternoon and tomorrow morning. And in terms of the scheme of those submissions, I will, if I may, address you briefly again in relation to the background. Mr. Chatswood has obviously covered that to some degree. We don't accept that it's a sufficiently balanced account. And I'll then address you in turn on each of the 3 points that I've just sought to summarise. So, turning then to the background, as has been explained, in 2017 and 2018, there were some limited and inchoate discussions between Vestel and First Advance, and then Second Phillips, over terms of a license for patents reading onto the HEVC standard. Now, important points to note, none of the parties is domiciled in England and Wales. That won't have escaped the court's attention. And no allegation has ever been made that Phillips has issued threats with regard to patent infringement, either here or elsewhere. Now, Vestel issued its claim in January 2019, and it alleged that Advance, and in the alternative Phillips, was abusing a dominant position on the various markets alleged to exist for licensing the SEPs reading onto the HEVC standard. And at that point, it was a claim as regards Phillips based solely on abuse of dominance. There was no other tort alleged. Now, what was particularly striking about that claim is that, in distinction to certainly every other claim involving Fran that I've acted in, there was no claim based on breach of contract or any other form of quasi-contractual claim. So ordinarily, in a Fran claim, you would expect to see the following broad pleas. Firstly, that the patent holder has given certain undertakings to a relevant standards body. Secondly, that the implementer is entitled to rely on those undertakings so that they become binding. Thirdly, that the patent owner has failed to honour those obligations, and therefore that there is a defence to a claim of infringement, or at the very least the relief that one would be entitled to for such a claim. And if we could go very briefly back to the Unwired Planet case in the Supreme Court, just to look at one paragraph in that, which picks up this issue rather well. That's in the third authorities bundle, and it's tab 27. Now, Mr. Segan was fortunate enough to remain in this case to its very end. My client, Samsung, settled out, so I missed out, unfortunately, on all of the fun pretty well. With apologies to my Lord Justice Birss, who's obviously particularly familiar with this, in the Unwired case, as Mr. Chatsfield explained, the patents in issue were essential to the ETSI standards, and the SEP holders had given undertakings to ETSI under the ETSI IPR policy. And if we could go, please, to paragraph 58 on page 7, that's bundle page 741. I just have to get myself. And one of the issues that arose in the case, as again Mr. Chatswood explained, was whether the court had jurisdiction to determine what would be FRAND terms for a worldwide license to the portfolio of patents that was held by the patent holder Unwired Planet. And the court responded, having heard the submissions of the parties. In addressing the submissions set out above, we recognise, as is undisputed, A, that questions as to the validity and infringement of a national patent are within the exclusive jurisdiction of the court of the state which has granted the patent, and B, that in the absence of the IPR policy, an English court could not determine a FRAND license of a portfolio of patents which included foreign patents. It is the contractual arrangement which ETSI has created in its IPR policy which gives the court jurisdiction to determine a FRAND license, and which lies at the heart of these appeals. So it's quite plain that in that case, what was absolutely core was the contractual framework that was created by the ETSI IPR policy. But as Mr. Chatsfield has explained, there are no equivalent contractual pleas in Vestel's claim. If we could go to that claim, that's to be found in the core bundle, tab 15. This is in its marked up form. And you were taken through this before, and I don't think it would have escaped the court's attention. Just to make clear, because Mr. Chatsfield, I'm not sure whether we quite see eye to eye on this point. The legal meat that put the paragraphs that put the legal meat on the bones of the FRAND dispute were those relating to abuse of dominance, and they begin at paragraph 68. And it was this allegation of abuse of dominance that was said previously to form the basis for the claim and to justify the declarations that were ultimately sought. And you saw the request for further information, the response to the request for further information, which made clear that the declarations sought as against Phillips were not freestanding. Now, and I'm going to come back to that in a moment. Now, Vestel declines to say whether in evidence or in submissions White admitted a contractual claim or even a plea based on contract in some way. And in reality, there are two plausible explanations. One is that it recognised that there was no viable contractual claim or plea. And the other is that Vestel recognised that even if there were such a claim, the English court would have no jurisdiction over it. But all it did in its particulars of claim, and it remains the case today, is the fleeting reference to the ITU obligations in paragraph 5. And that's not a pleaded contractual claim at all, as I'll explain. So at this point, Vestel was putting all of its eggs, both the claim and jurisdiction, in a basket which we can label tort, abuse of dominance. Now, we then had the applications to challenge jurisdiction by both my clients and Advance, each made under CPR Part 11. And in Phillips' case, the application was made on the simple ground that it is domiciled in the Netherlands. The general rule under Article 4.1 of the Brussels Recast Regulation is that it shall be sued in that domicile. And in response to that challenge, Vestel sought to rely on the exception under Article 7.2. Now again, I'll come back to the details of that provision in a moment, but for present purposes, it provides materially that a person domiciled in a member state may be sued in another member state in matters relating to tort, in the courts for the place where the harmful event occurred or may occur. Also, really, it's both prospective as well. It comes on to the point I'm going to deal with when Mr. Chatsfield says he couldn't have pleaded his new version of the abuse of dominance case. Now, it was common ground below, and I understand remains so because I heard nothing to indicate otherwise, that in the light of the case law of the Court of Justice, the harmful event for these purposes encompasses two potential limbs. The event giving rise to damage and secondly, the damage itself. Now, Vestel relied only on the latter, the damage itself, and only in the sense that damage to Vestel had occurred or may occur in England. And it was common ground below, and again, I understand it remains so, that Vestel had to show a good arguable case in that regard, including that there was credible evidential basis for its case on loss. So we then had the judgment below, and the judge held that the English court had no jurisdiction over Phillips, and he's held so for the reasons that are set out at 61 to 67 of his judgment. And if we could go, please, very briefly to that judgment. It's in the core bundle, tab 9, and to paragraph 67, where he summarises his findings in relation to the claim under the Brussels regulation against Phillips. It says this: in my view, none of the evidence filed discloses any credible basis on which to conclude that Vestel UK has suffered or will suffer any damage arising out of the alleged abuse of a dominant position by Phillips, assuming that such abuse were proved at trial. So the reason, in simple terms, why Vestel failed is because it simply didn't file any credible evidence to support its foundational assertion that the alleged abuse would cause it any loss at all, let alone in England. So that was the situation following the judgment. And then we have the series of volte-face by Vestel. So initially, having lost, it sought to challenge the judge's decision with regard to Phillips on two grounds. There was the primary ground, ground 2, that the judge had erred in finding that there was no direct damage caused by the alleged abuse in England. And then there was the secondary ground, ground 3, which occupied just one paragraph of its original skeleton argument. And that introduced a new contention to the effect that the claim for abuse of dominance should somehow be analysed under Article 7.2 as one for UK patent infringement. Now, one of the points that we responded to when dealing with that is we said, well, we don't really understand that. Is it a claim for patent infringement or is it a claim for abuse of dominance? We're confused, that the two seem to be in tension with one another. And Vestel sought to resolve that difficulty by its application on the 2nd of February, by which it abandoned ground 2 and sought permission to amend its claim form and particulars to remove the allegations of abuse of dominance. Now, insofar as it was merely removing allegations of abuse of dominance, that is, it is taking things away from its claim, it is common ground that they were granted permission by Lord Justice Arnold for that change. What is not common ground is the second aspect, which is that insofar as they removed the allegations of abuse of dominance, they thereby introduced a new claim against Phillips. Because originally, the claim for declarations was based solely on the allegations of abuse of dominance. And so obviously, if you take away the allegation of abuse of dominance, but you keep the claim for declarations, you are fundamentally changing the nature of the claim, because now the claim becomes one for a freestanding declaration. And that was never the claim that was advanced below. And I'm going to go, if I may, to the transcript of day 2 of the hearing on this point. I didn't think I'd initially have to do that, but given Mr. Chacksfield's submissions, I think it's important probably that we go there. So if you go to please the supplementary bundle and go to tab 25, this is day 2, and if you could go please to page 304 of the bundle, this is page 88 of the transcript. There's an exchange here between myself, the judge, and counsel for Vestel, who then was Mr. West. Begins at line 15 on page 88. A further loose end arises in relation to the question that I just referred to, which is whether it's being suggested by Vestel that if they lose on their claim of abuse of a dominant position against us, they can nonetheless obtain a declaration in relation to Fran. Yesterday, I explained that I understood they were not making that point. I also note that they were making it against Advance, a different regime, I think I meant to say under a different regime, but they were not making it against us in recognition of the fact that, under the Brussels regulation, they can only obtain jurisdiction in relation to matters relating to tort. And there is no 4A, that should be the number 4A equivalent. I'm slightly unclear as to where Mr. West has left that. I was concerned this morning that he might be backsliding from that position and suggesting that they can, if they lose an abuse of dominance, nonetheless obtain a declaration. Judge Hacon, he is shaking his head. Mr. West, I am not. I'm grateful that addresses the point. So absolutely crystal clear. We questioned what their case was below, and they made it abundantly clear that there was no, they were not seeking a freestanding declaration. Their success or otherwise depended on the case for abuse of dominance.
So I am not, does not mean I'm not shaking my head. It means I'm not seeking a declaration.
That's right.
That's certainly how you seem to have understood it.
That's how I understood it. I think that's how the judge understood it. It's also in accordance with, I don't think we need to go back to it now, but you were taken to a request for further information and a response, and it's in accordance with their response there as well. So they were asked that question in that request, and they said, no, we're not seeking a declaration that doesn't depend on our claim for abuse of dominance. And Mr. Chaxford showed you that. But it was because of some concerns that they were backsliding that I asked the question, and we got the confirmation. So there are a number of points to make that follow from the case as it was articulated below. Firstly, there was simply no debate before the judge, nor any analysis in his judgment as to whether Vestel's claim against Phillips was a matter relating to tort for the purposes of Article 7.2. Obviously it was, on the basis of the claim then put, because the tort was the breach of statutory duty arising from the alleged abuse of dominance. And it won't have escaped this court's attention. It's been a rather unusual appeal so far. We haven't really looked at the judgment. We haven't been taken to taken through and criticised each of the areas where the judge went wrong on this fundamental claim, because he simply didn't address it. Second point is that the debate was focused on whether there was any harmful event in the sense of direct damage in England. And as I showed the court, the judge found not so on the facts. And Vestel now concedes that it cannot appeal that finding on the facts. Third point is, for obvious reasons, given that it wasn't how the claim was put, there was no discussion of whether an entirely freestanding declaration of the sort that Vestel now pleads was justiciable. And your lords will look in vain in the pleaded case for a coherent explanation, at least, of the supposed legal basis for the declaration that Vestel now seeks. Talk went, which seems to imply that it must be contract, but in connection with contract, the best that Vestel can point to is the fleeting reference in paragraph 5 to the ITU, and that's not a proper contractual plea, and indeed Vestel seems to accept that now. And so there is therefore no justiciable basis pleaded for the declaration sought. What we now have is an attempt to revert back to abuse of dominance without that point actually properly being pleaded. So my lords, that's my lords and my lady, that is the background. And I now turn to the first point, which is the procedural propriety of the amendment. And I say that the court should not allow the amendment for 3 reasons. Firstly, it would be procedurally inappropriate and unfair to do so. And if the court, please, could turn to the authorities bundle in CPR Rule 5221 briefly. So this is tab 5 and page 61, an extract from the White Book. And we have CPR Rule 5221 set out there. There are 2 relevant provisions to which I'd like to draw attention. Firstly, subparagraph 1, every appeal will be limited to a review of the decision of the lower court unless A, a practice direction makes different provision for a particular category of appeal, or B, the court considers that in the circumstances of an individual appeal, it will be in the interest of justice to hold a rehearing. And then 3, the appeal court will allow an appeal where the decision of the lower court was A, wrong, or B, unjust because of a serious procedural or other irregularity in the proceedings in the lower court. Now, 5221(3) makes clear that what Vestel wishes now to pursue before this court is not only not a review of the lower court's decision, it's not actually an appeal within the sense of that provision at all. Vestel alleges no procedural irregularity, serious or otherwise, and it cannot, with regard to the judgment in respect of Phillips, point to anything in the judgment of the judge that the judge got wrong at all. On the contrary, Vestel's case is that had the judge been considering a different underlying claim, that is one for a freestanding declaration, and an entirely different asserted basis for jurisdiction, then he should have decided that there was jurisdiction to hear that different claim. But in my submission, that's not an appeal. That is an illegitimate attempt to turn this court into a first instance tribunal. And there are a number of reasons in my submission why that is problematic. And the first one is this. We have a system in this jurisdiction that, for good reason, requires claims to be brought and properly ventilated in the High Court, claims such as this one, to be brought and properly ventilated in the High Court or potentially the Competition Appeal Tribunal. And if either the High Court or the Tribunal arguably get something wrong in its decision, then it's the job of this court, the Court of Appeal, to be able to scrutinise that first instance decision with the benefit of all the parties in first instance court having considered the issues once before. Now, for most cases, that two-tier system is the end of the road, because obviously the Supreme Court can only hear a very limited number of cases. And also commercially, it seems to strike a fair balance for many companies between, on the one hand, having 2 chances to get the right answer, and on the other hand, it being unviable to litigate points time and time again. Now, that system of having the original decision maker's decision reviewed and scrutinised enables the courts to produce more robust results, and that benefits the application of the law as between the parties, and it also benefits the wider legal system by helping to produce more robust decisions, which act as precedents for other potential court users. Now, Vestel's approach in respect to Phillips of abandoning both its claim and the basis for jurisdiction advanced before totally subverts that system. The likely reality is that there will now be no second court that scrutinises this court's decision, and that means that there will be no opportunity for review of the original decision maker's decision in relation to it. Now, of course, given this court's expertise, we'd fully expect this court to reach the right result in any event. But that, I would suggest, somewhat misses the point, because hearing this appeal as it's now put will mean that the safeguards that the court system as a whole has in place to produce better, more robust decisions will have been undermined. This court will not be looking to see what the first instance court got wrong. It will be transforming itself into the first instance court. And that's not only wrong as regards the system, as I just explained, it's also unfair on us because Vestel is forced to suffer that disadvantage because it's it that wants to change its case, and indeed change its case yet again at the last minute this morning. So for Vestel, it's that will go home. But there's no real reason why its U-turn and the problems associated with it should be visited on my clients. That's simply unfair. Second type of unfairness is that Philips has based its stance in this litigation for coming up now, and had over 2 years, on the basis that this was a claim for abuse of dominance based on excessive pricing. And that's not only before this court, but also before other courts in Germany and the Netherlands. And had Vestel previously been pursuing the new case for which it now seeks permission, we would have been afforded the normal opportunity to seek to understand that new claim through a process of request for further information. We could have examined that legal framework. We could potentially have advanced evidence in relation to it. Instead, we've been discovering what Vestel's claim is as recently as this morning, and that is wholly unsatisfactory. So, my lords, that's my first submission on the amendment, which is that it's procedurally improper. My second point on the amendment is that it shouldn't be allowed, and the reason why is that it corresponds to the second point of why the appeal shouldn't be allowed, and that's because this court has held, in the context of the predecessor to the Brussels recast regulation, that it's not permissible to add by way of amendment additional claims unless the jurisdictional requirements are fulfilled for those claims. That's the Masri case. For your note, it's Authorities 1, tab 10, and it's bundle page 173, tab 74. It's a fairly obvious point. The court needs to be satisfied that in order to allow the amendment, there would be jurisdiction for the amendment. You can't subvert the whole system under, say, the Brussels regulation by getting permission for one thing and then amending and bringing in something which you would never have permission in the first place, or for which there was no jurisdiction. And then the third and final point on the amendment, again, has its parallel in the substantive points that I'm going to make, which is it's for the party seeking permission to show that the amendments have a real prospect of success. And that is obviously an uncontroversial proposition. It's found in the White Book at 17.3.6. And it will be my third main point on the appeal that this claim is simply not justiciable. So, my lords and my lady, those are my submissions on the question of amendment. And I turn then, if I may, to the second of the three main reasons why the court should dismiss the appeal, namely the lack of international jurisdiction in relation to the new claim.
Mr. Pickford, before you do that, I have at the back of my mind that not in this field, but just as a general proposition, there is quite a lot of authority on when new points of law can be taken on appeal. The general position, I think, being established for well over 100 years, that if there's any possibility the evidence might have been different, then new points of law are to be not allowed. But if it's simply a different way of putting the legal case based on the same facts as were in issue below, then this court does have power to permit a new way of putting the legal case to be run. How does that square with what you've said about 5221?
Well, my lord, I'm not saying that there is no power, but in the exercise of the court's jurisdiction, discretion, it should take account of the fact that in this case, the extent of the change of case is to render the entire basis of the claim for jurisdiction and the underlying claim on which it is made entirely new. This is not simply a case of there being a finessing of a legal point. As regards Philips, none of the judgment below basically has any relevance to the claim as now pursued by Mr. Chatsfield, save insofar as he seeks to, having on the one hand conceded that he can't challenge the judge's decision on the facts, he seeks, in fact, in reality, to actually try to bring some of those facts back again. But my submission, my lord, is that in a case that is that extreme, one does face the problem that you are effectively subverting the two-tier system if you allow such an appeal to proceed. There's obviously there's a balance, and when it's just one small point amongst many, one can well see why, if there's no prejudice in relation to the evidence, why one might permit such a case to proceed. But this is not that case. Even in relation to the claim as it was advanced about a month ago, we have the further difficulty now that actually much of what Mr. Chatsfield says to seek to justify his new claim is something that is absolutely brand new, not from a month ago, but from this morning, because we're seeking to somehow resurrect the abuse of dominance claim through the back door.
Yes, thank you.
So, turning then to the question of international jurisdiction, the reason why there is no such jurisdiction in this claim is twofold. Firstly, it's not a matter relating to tort, and secondly, Vestel has failed to establish jurisdictionally relevant damage. So I'm going to first, if I may, develop the legal principles, and then I'm going to seek to apply them in this case. So if we could start, please, with the Brussels Recast Regulation. That's to be found in the Authorities Bundle, Volume 1, Tab 2. And I'd like, if I may, to begin by looking at Recital 15. That provides that the rules of jurisdiction should be highly predictable and founded on the principle that jurisdiction is generally based on the defendant's domicile. And then at 16, in addition to the defendant's domicile, there should be alternative grounds of jurisdiction based on a close connection between the court and the action or in order to facilitate the sound administration of justice. The existence of a close connection should ensure legal certainty and avoid the possibility of the defendant being sued in a court of a member state which he could not reasonably have foreseen. And then we have the general rule in Article 4.1, which is on page, it's external page 19. That subject to this regulation, persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. Now, as we saw in Recital 15, that reflects the important principle and the general purpose of the regulation in terms of achieving legal certainty. However, there are limited exceptions, and they are to be found in Article 7 and following, but it's Section 2, Special Jurisdiction. We're concerned, obviously, with Article 7. I'm going to begin with Article 7.1, because it's actually relevant to some of the points that arise in this case. A person domiciled in a member state may be sued in another member state, 1A, in matters relating to contract in the courts for the place of performance of the obligation in question. And then that concept is then defined in B. And then we have 7.2. They may also be sued in matters relating to tort, delict, or quasi-delict in the courts for the place where the harmful event occurred or may occur. So these are examples of special jurisdiction, which provide for exceptions to the general rule. And Article 7.1, as I noted, concerns contract. The reason why I mention it is because we do have some hints about a contractual claim, but of course there is no explanation of where the contract would be performed, and one has to infer but the answer is not one that Vestel likes. So they haven't sought to rely in jurisdictional terms on contract at all. What they do rely on is Article 7.2, and the Court of Justice of the European Union has consistently emphasised high-level points in relation to Article 7.2. The first of those is that Article 7.2 is an exception to or derogation from the general principle that a defendant shall be sued in the member state of its domicile. And in consequence, it has to be interpreted restrictively. And that in turn requires there to be a particularly close linking factor to justify the attribution of special jurisdiction. Now, you heard Mr. Taxfield's submission that in fact Article 7.2 is to be given a broad interpretation. That's simply wrong, and I'll show you in the jurisprudence why his submission is wrong in that respect. So if we could begin, please, with the Supreme Court summary of the principles that are derived from the jurisprudence of the Court of Justice, and that's to be found in the AMT Futures case, which is in Authorities Bundle 2, tab 19. So, as one sees from the head note, this was a case involving a large number of financial services agreements made between the claimant, a financial services provider in the United Kingdom, and its clients, and each contained a clause providing for the exclusive jurisdiction of the English courts. The claimant alleging that a number of its former clients have been induced by the defendant, a German law firm, to bring proceedings against it in Germany in breach of their applicable agreements, began proceedings against the defendant in the High Court on the basis of the tort of wrongfully induced contract, seeking inter alia damages for the costs of defending and settling the claims brought against it in Germany. Since the defendant was domiciled in Germany, the claim could only be brought in England if the harmful event had occurred in England within the meaning of what was then Article 5.3 of Council Regulation 44 of 2001. That now corresponds to Article 7.2 of the recast regulation. So if you could go then please to bundle, well, what I have, so I'm using the electronic bundle page 470, which is paragraph 11 in the judgment of Lord Hodge. Sorry, 470 in fact is just showing that everyone agreed with Lord Hodge. But if we then go to paragraph 11, which is on bundle page 473, we have the following summary of the case law in relation to the judgments regulation. It contains rules of jurisdiction which are designed to promote legal certainty by allowing prospective litigants, whether claimants or defendants, to foresee with sufficient certainty which court will have jurisdiction. The aim of the judgments regulation is to prevent parallel proceedings between courts of different member states and thereby avoid or limit irreconcilable judgments and non-recognition of judgments. The compulsory system of jurisdiction which the judgments regulation creates is underpinned by the principle of mutual trust between the courts of the member states. And then at 12, the general principle is that civil actions are to be brought against individuals and companies in the courts of the place where they're domiciled. It would be contrary to the objectives of the judgments regulation to interpret it as requiring the recognition of the jurisdiction of the courts of the claimant's domicile, except where it expressly so provides, as that would enable the claimant to determine the competent court by choosing his own domicile. The derogations from the general rule, which confers jurisdiction on the courts of the defendant's domicile, including Article 5.3, now 7.2, must be restrictively interpreted in order to achieve the aims of the judgments regulation. The derogating grounds of jurisdiction are justified because they reflect a close connection between the dispute and the courts of a member state other than that in which the defendant is domiciled. That close connection promotes the efficient administration of justice and proper organisation of the action. And then, if we could then please go to paragraph 15 over the page. The Court of Justice of the European Union has ruled that the correct approach to Article 5.3, has ruled on the correct approach, I beg your pardon. It has interpreted the phrase, the place where the harmful event occurred, so this is the second limb after the fact that it must be a matter relating to tort, A, to give the claimant the option of commencing proceedings in the courts of the place where the event occurred which gave rise to the damage, or in the courts of the place where the damage occurred if the event and damage were in different member states. B, as the place where the event giving rise to the damage and entailing tortious liability, I emphasise there, event giving rise to damage and entailing tortious liability, directly produced its harmful effect upon the person who is the immediate victim of the event, and thus not the place where the indirect victim, such as the parent company for the immediate victim, suffered financial loss as a result. And then C, consistently with the above, where a victim suffered harm in one member state and consequential financial loss in another, referring to the place where the initial damage occurred. The focus in B and C is thus on the direct and immediate damage occurred. So this is a restrictive approach to the interpretation of 7.2. And it's also manifest in paragraphs 31 and 32. And if I might just ask the court to read those. This is summarising the Calfalis case, which I'm going to come on to very, very shortly. So, thank you, my lord. What one takes from that is it's only insofar as the claim is one in tort that the special jurisdiction arises under 7.2. And that's even if there is a connected contract claim. And if that is inconvenient, well, that's just tough. The point being made here is that that's the price that one pays for legal certainty under the regulation, which is the overriding principle, and drives the narrow construction of the exceptions. And moreover, of course, there's always an answer that if you want to bring all your claims in one place, because that's the sensible and convenient thing to do, you can bring them in the member state where the defendant is domiciled, because you can always sue under the general rule in Article 4.1. So we then move to the principal requirements for relying on Article 7.2. And as I explained, there are two essential requirements that need to be established. The first is that proceedings need to be matters relating to tort, and the second is that the court seized must be those for the place where the harmful event occurred or may occur. So starting then with the first of those, as I just showed you, it's critical that it's only that part of the proceedings that relate to tort that where Article 7.2 applies. And if I could take you, please, to the leading authority on the discussion of matters relating to tort, which is the Calfalis case, which we went to before, but I'd like to go through it just slightly more carefully. So that's in the authorities bundle 28. That's authorities 3. And could I just ask, because it may be that I'm just providing entirely superfluous information here, I'm using the electronic bundle, so the electronic page numbers mean something to me, but I don't know whether they mean anything to anyone in the court, so I'll stop mentioning them if they don't.
I'm using paper bundles, and they're of no interest to me at all.
Noted.
Same here.
They're very helpful for me, Mr. I'm using the Elektronik.
Well, okay, well, in which case, that's good enough for me, so I'll continue to use them. So if we could go, please, to paragraph 3, which is on Elektronik bundle page 776. So this does set out the key facts, and the takeaway from this, the key point to note, is that the claim in issue was based both on contractual liability and on unjust enrichment. That's the key factual context that we need to understand the paragraphs that then follow. So then we go to the question that was asked by the court, the second question, which is at paragraph 14. That's page 779. And the second question submitted is intended essentially to ascertain first whether the phrase matters relating to tort, delict, or quasi-delict used in Article 5.3 of the Convention must be given an independent meaning or be defined in accordance with the applicable national law. And secondly, in the case of an action based concurrently on tortious liability or delictual liability, breach of contract and unjust enrichment, whether the court having jurisdiction by virtue of Article 5.3 may adjudicate on the action insofar as it's not based on tort or delict. That's the second of those issues that we're particularly concerned with. And as Mr. Chatsfield rightly noted, the key passage that answers that question begins at paragraph 16. And we see, I'd like to just emphasise the following points, in particular, that paragraph 17, in order to ensure uniformity in all member states, it must be recognised that the concept of matters relating to tort, delict and quasi-delict covers all actions which seek to establish the liability of a defendant and which are not related to contract within the meaning of Article 5.1. It must therefore be stated in reply to the first part of the second question that the term matters relating to tort, delict or quasi-delict within the meaning of the article must be regarded as an independent concept covering actions which seek to establish the liability of a defendant which are not related to contract within the meaning of Article 5.1. And then with respect to the second part of the question, it must be observed, as already indicated above, that the special jurisdictions enumerated in Articles 5 and 6 of the Convention constitute derogations from the principle that jurisdiction is vested in the courts of the state where the defendant is domiciled, and as such must be interpreted restrictively. It must therefore be recognised that a court which has jurisdiction under Article 5.3 over an action insofar as it is based on tort or delict does not have jurisdiction over that action insofar as it is not so based. Whilst it's true that disadvantages arise from different aspects of the same dispute being adjudicated upon by different courts, it must be pointed out, on the one hand, that a plaintiff is always entitled to bring in action in entirety before the courts of the domicile of the defendant, and on the other, that Article 22 of the Convention allows the court first seized in certain circumstances to hear the case in its entirety, provided there is a connection between the actions brought before the different courts. And then in 21, basically repeats the formulation that Article 5.3 does not provide jurisdiction over an action insofar as it is not based on tort. And then one sees the same thing in the operative part, subparagraph 2b. So the following principles emerge from this case. First, in order to invoke Article 7.2 and for a matter to be relating to tort, in fact, the claim must be based on a tort. And secondly, based on a tort has two elements. It is a claim which firstly seeks to establish the liability of a defendant, and secondly, which does not concern matters relating to a contract within the meaning of Article now 7.1. And so third, by implication from those first two propositions, and as the Court of Justice expressly held, Article 7.2 does not apply to proceedings insofar as they are not based on a tort. That is, insofar as the claim does not seek to establish liability through the allegation of a tort. Now, I'll come on to declarations of non-liability in a moment, but in my submission, the same essential principles apply, just reversed. So the courts subsequently applying that guidance in Calfelis have consistently held that non-contractual claims seeking relief otherwise on the basis of liability in tort fall outside Article 7.2. And I'd like to look briefly at 4 cases, and these really are instructive, and go to the really very much the heart of the issues in this case as regards Phillips. So the first case is the Reichert and Dresdner Bank case, which is to be found in Authorities Volume 3, Tab 29. And if we could go, please, to paragraph 3, that sets out 3 through to 5, in fact, set out the core facts. The essential point that's made here, that's relevant for the discussion that follows, is that there is a procedure in French law, under the French Civil Code, by which creditors may challenge in their own name transactions entered into by debtors in fraud of their rights, and it's known as the action polienne. And the key point in relation to it is that you don't need to bring your action polienne against someone who has committed a wrong. So a third party purchaser in good faith can still be the subject of an action polienne. And the point of the action is it's to operate as against that third party, irrespective of whether it's done anything wrong itself.
Yes,
and
Mr. Pickford, the agreed timetable had you going till 4:15. I thought I'd just better check with the other members of the court if there's any problem carrying on till 4:30. Lady Justice Laing? Justice Birss? No. Well, I suggest you continue to 4:30, Mr. Pickford.
Thank you, my lord, and I apologise for the inadvertent seeking indulgence. I hadn't actually realised we've got to 4:20. So if we could then go, please, to paragraph 12. That sets out the terms of Article 5 of the Convention, and then the submissions of the Dresdner Bank respondent were that the action polienne comes within the scope of Article 5.3, inasmuch as it's a revocatory action, which, as such, aims at rendering ineffective a culpable or deliberate act or omission which is contrary to the law or to unwritten laws of care and causes damage to a third party. The Commission, intervening in this case, on the contrary, thinks that the action polienne, which may affect a third party acting in good faith, and which therefore has therefore not committed any wrongful act or omission, and which not only leads in certain circumstances to imposing on such a party acquiring the obligation to make reparation, but may also result in an indirect depletion of his assets, cannot be regarded as an action for liability in tort delict or quasi-delict. It does not over Article 5.3 of the Convention. That sets up the competing positions. And then there is 15 and 16 a reference to failings, which we've just seen, so I think I can skip over that. And then we have the key reasoning at paragraphs 17 through to 20. And if I could ask, please, the court to read those 4 paragraphs.
Yes.
Thank you. So what's core here is there an action which doesn't depend on and seek to establish a defendant's liability for damage caused by a wrong does not fall within Article 5.3 of the Brussels Convention. And in that case, the action didn't seek to establish the defendant's liability for damage caused by a wrong. Rather, it was to set aside a transaction against a third party who might be entirely innocent, and therefore it fell outside the autonomy of based on a tort. So the next case is the Kleinworth-Benson case, and that's in Volume 1 of the authorities at tab 7. And the head note sets out the key facts. I think for our purposes, to summarise, make sure we get through this. The key issue was that the question on which I want to take the court to is about whether the banks in this case were entitled to bring their actions for restitution in England. So it's a question about restitutionary actions under what was then the judgments regulation. And if we go, please, to bundle page 99, which is of the report, page 172. And this is Lord Gough dealing briskly with an argument that was advanced by Mr. Pollock for the bank. And it was said, before the appellate committee, Mr. Pollock for Kleinworth advanced a brief argument to the effect that Article 5.3, which is concerned with matters relating to tort, delict or quasi-delict, and places jurisdiction in the court for the place where the harmful event occurred, or in the case of a threatened wrong, is likely to occur, applied in cases of unjust enrichment, and was therefore applicable in the present case. This argument is impossible to reconcile with the words of Article 5.3, if only because a claim based on unjust enrichment does not, apart from exceptional circumstances, presuppose or a threatened wrong. And other members of the House of Lords agreed. So just reinforcing the point in relation to unjust enrichment claims. And then I think we can probably just get through Excel and AXA, and that will, I think, round off today reasonably satisfactory, if we may. So that is at tab 17 of the second authorities bundle. So this is a decision of His Honour Judge Waxman. And we see from the head note that it was an application by the defendant French insurance company AXA disputing the jurisdiction of the English court to hear and determine proceedings brought against it by its co-insurer XL. XL and AXA were co-insurers of a US train operator, Connex. 24 people have died and many have been injured in a collision involving a train operated by Connex. Proceedings have been issued against it on behalf of the victims. A fund of 200 million was established for allocation to the victims. XL paid 65 million US dollars into the fund, but AXA denied any liability to make a contribution. And then AXA argued that as a French domicile defendant, it should have been sued in France pursuant to Brussels 1 Recast Article 4.1. It contended that neither of the derogations of that general rule applied under Article 7.1, matters relating to contract, or Article 7.2, matters relating to tort. And then at paragraph 27, the judge deals with the argument under Article 7.1, and the reason why I refer to it is because it is analogous. He goes on to explain it's analogous to the point that arises under Article 7.2. So if I could ask the court just to briefly look at paragraphs 27 and 28, which are on page 410 of the electronic bundle. So the key point here in the context of Article 7.1 is that it wasn't sufficient for the claimants to point to a contract which wasn't the basis for the claim. They couldn't point to a contract in the background. The key point is the contract which is actually the basis of the claim has to be the one which is used to found jurisdiction. And then at paragraph 32 and following, the judge turns to Article 7.2, and then there's a fairly lengthy survey of the relevant cases, the most pertinent ones of which are the ones that I've already taken the court to. So that's Calfalius, Reichert, and Claimants. And then he draws his conclusions in summarising the law at paragraph 67. And if I could just ask the court to read paragraph 67.
Yes.
So key points to draw from that is, in particular, sub 3, the liability should be allied to the requirement for a harmful event. And then just as under Article 7.1, the fact that there is a contract in the however important, does not necessarily bring the claim within it. So the fact that there may be a harmful event, properly so called, in the background, however important, does not itself bring a claim which is not within Article 7.1, within Article 7.2. So key point there is that if the claim is not based on the tort in question, in the sense that that is the tort which gives rise to liability, it can't make it, it can't be the jurisdictional hook for a claim under Article 7.2. Claims that are in the background are not good enough. My lords, if that's my lady, if that's a convenient place to pause, I could pick it up again tomorrow morning.
Yes. We're due to recommence at 10:30. Are you reasonably on track, Mr. Pickford?
I think I'm reasonably on track. Yes, my lord.
Good. Well, we'll say 10:30 then. We'll see you tomorrow.